SJC-12678, Commonwealth versus Jose Ramos.
Okay, Attorney Tempowski.
Good morning, Your Honors. Michael Tempowski for Jose Ramos. The defendant is entitled to a new trial for two independent reasons. The first is that the trial counsel failed to introduce adjutant evidence which would have been admissible and which, in our view, would not have been subject to rebuttal. Second, trial counsel should not have, and by doing so, created a substantial likelihood of miscarriage of justice, withdrawn his request for the sudden combat manslaughter instruction. So first I'll address the adjutant issue. And there's a couple points I want to make to frame that issue before I get into the details. The first is that adjutant evidence admitted against an alleged victim in a possible self-defense case, and then counter-adjutant evidence that the prosecution would offer against the defendant is actually not subject to the same balancing test, and that's an important consideration. The balancing test applicable to prior bad acts offered against a defendant is more favorable to the defense than the traditional 403 analysis, and that's under the Creighton case that this court has laid out. And that's an important framing. So it's actually harder for the Commonwealth to introduce counter-adjutant evidence than it is for the defendant to introduce.
We're talking about strategic choices, though, right?
But I think that has to factor into whether the strategy.
I get the legal framework, but we're still talking about a strategic choice that defense counsel has to make, correct?
Yes, that's how counsel explained his decision not to pursue this. But the second point I want to make to frame this is why I think that decision was unreasonable.
And that was accepted by Judge Callan, right?
It was, yes. Yes. Is the way that this would actually play out is not, this doesn't play out in front of the jury, is that the trial counsel would file a motion to admit adjutant evidence and a motion to exclude, or the Commonwealth would file a motion to admit counter-adjutant evidence. And then there would be a ruling, and then the defense attorney would have the privilege of deciding whether to pursue it or not, because only when they pursue the adjutant evidence could the Commonwealth rebut it. And so if the ruling doesn't come out in a way that they think is favorable to the defense, then they won't pursue it at all. And so the idea of just deciding pre-trial without any attempt to bring it before the trial court as to what you're going to do in that situation doesn't make a whole lot of sense. At a minimum, you ought to try to bring the issue up to the trial court ahead of time and see what the ruling would be. So I think going back, I think it calls into question whether this is sort of a post hoc rationalization on the part of trial counsel or whether that was really a strategy. And if it was, whether that strategy was reasonable, the more reasonable thing.
I mean, is there some reason why the judge could not credit the attorney's affidavit, defense counsel's affidavit?
Some reason why they couldn't?
Yeah, because he credits the explanation. And the first part of the explanation, he says, well, that's just legally wrong. You misunderstood the law, the idea that you couldn't get it in.
Right.
But the second part, he's like, yeah, I credit that it was a strategic decision because defense counsel was worried about the counter adjutant evidence coming in, and it's a mixed bag, right? I mean, if it did come in, it's it's not necessarily going to help your client, and it may in fact just be a wash. But why couldn't the judge credit the attorney's explanation in his affidavit?
Well, I think as a factual matter, the judge did credit it.
Yeah. So and
challenge that factual determination.
And so then, isn't that sort of the end of this particular argument from our perspective on appeal, given the standard of review?
I don't think so, because I think whether the strategy was manifestly unreasonable is not a question of fact.
I see.
So the court would still have the ability to say that that decision was wrong as a matter of law. That's how I would.
Well, considering the jurisprudence on what manifestly unreasonable is, even accepting your view that you're right about, that it's harder to get in prior bad acts. In a case like this, where nothing was captured as to the ultimate stabbing of the victim, where it really would have been hard to argue against adjutant evidence coming in one way and then also being introduced against your client, because this case really didn't have an eyewitness. It had all kinds of other atmospherics with, the two of them and the animosity between the two of them. So when you say that it would be unlikely for the prosecutor to introduce the prior bad acts against your client, doesn't that really make it seem strategic that you wouldn't do this because you would probably come in from the Commonwealth's perspective?
I mean, that's what the motion judge found.
Oh, that's what you're arguing here, because that's all you have, because we have the factual findings. So your argument has to be that it was manifestly unreasonable because it would be unlikely that the Commonwealth. So I'm saying, based on the facts of this case, how do you say that?
Sure. So there's a couple of ways. So I pointed out the burden, the 403 test being more restrictive of the Commonwealth there. There's also the practical realities of the, this is a 2018 trial. Some of these convictions are even, many, many years before that, before the court was in, storing things digitally. And we presented evidence that at least as to one of Mr. Ramos's convictions, that there would have been no record. Trial court records would have been destroyed.
They had a record.
Well, they had their file.
Right. So that all they need is the name of a victim.
If they can find the person.
Yeah, this all leads to speculation, right?
Well, sure, but the Commonwealth saying we had our file is a far cry from a demonstration that means they'd be able to.
Well, isn't it the same? Isn't the same for you, that you would have to show that the sexual assaults the victim was convicted of were provable, and that you had the ability to call those witnesses?
Well, we had a plea colloquy for that, so I think that would be sufficient in our view. Right, so we had the record of the victim's guilty plea to the sexual assault cases, and so clearly that would have been available to trial counsel as well. And
I guess the question of law isn't whether you as trial counsel might have made a different choice, but whether this choice, given the balance of the defendant having his own baggage, the victim having his baggage, that it was just outside what the ordinary fallible lawyer would have done in weighing the pros and cons. That to me is your biggest problem. Not so much that a different lawyer might have made a different decision, but that this decision was completely unreasonable.
I understand that's the Commonwealth's argument, and I guess I just respectfully disagree. I think that given the way the Commonwealth was framing the case, which was that this was an unprovoked, essentially, stabbing in the back on video, and that was essentially their theory, that was their closing argument. The defense really decided to pursue self-defense here. If you're going to do that, you really have to marshal whatever you can. And I think to leave this on the table is not a reasonable decision under these circumstances. The defense had essentially one witness that raised the issue of self-defense or mitigation potentially. And that witness had problems. I mean, all the witnesses, there are various contradictions in various witnesses' statements. But the defense witness, there were definitely issues with the defense witness. And I think if you're trial counsel, you can't rest all your laurels on one inconsistent statement from someone else in that particular residential facility and hope that is enough to get a reasonable doubt on self-defense or on mitigation. I think you have to take that chance, even if that chance is that the Commonwealth may be able to show that your client did in the past engage in some act of violence at the expense of also showing that the victim did so, particularly given that that as the video was shown, it is the defendant who chases him down from behind. So the jury already knows that the defendant is capable of at least fighting behavior. So an additional assault and battery conviction from 10 years prior, I don't really think is going to make the jury think that much less of him.
How do we weigh the argument about the adjutant with squaring that with the jury's ultimate verdict? Because they were given manslaughter.
They were given 2 theories of manslaughter, not
So
3.
how do you, but how do you, they rejected those, right?
They did.
So, I mean, at some point, they said that whatever it is that you were arguing in terms of what the provocation was for this was rejected.
So I would say 2 things to that. I think one, that actually underscores why it was important to have evidence of the victim's history of violence to make it more plausible that the victim was the first aggressor, because as the evidence went in, there wasn't a lot of it other than one inconsistent witness.
Well, there was still evidence of self-defense. I mean, I understand you didn't think it was the best, but they still heard it.
It got instructed. It did. And 2 theories of manslaughter got instructed, not sudden combat, which I would also like to address.
The judge also found it would have been unlikely that Judge Sweeney, in her discretion, would have allowed in evidence concerning rapes of child and indecent assault and battery, because we can discuss, and we've done it in the context of 58A decisions about crimes of violence in those cases involving consent or lack of consent and inability to give consent. How do you square your argument with that finding by Judge Cowan that these are unlike the traditional cases involving aggressive conduct, assault and batteries, stabbings, etc.?
I mean, it's true. They're not. This is not a prior stabbing with a screwdriver, to be sure.
No, it doesn't have to be just traditional acts of violence.
So what I would say,
we don't look for similar kind stabbings with screwdrivers. But if there's a bar fight, sure.
Mm-hmm. No, I understand the point. I would say that I disagree. Just to back up, I think you asked also about 58A and how that sort of plays into it. I think that's a different situation because that's an elements-based test, and this is factual. And if you look at the facts of the event, it was a violent event. Whether he was charged with rape by force or statutory rape is really of no moment, I don't think, under the, for the adjutant purposes anyway, because the act, as described, was a violent act. And so, in my mind...
Would the judge have to do a prejudice versus probative balancing on the admission of the adjutant evidence under 403?
Yes, absolutely.
Don't you think that would cut against admissibility of those types of offenses?
I mean, I think...
As a trial judge, I would have a lot of concerns about the prejudicial effect of these.
So I would say that prejudicial effect as it relates to the Commonwealth or even a victim is really, in my view, less of a concern.
Does the Commonwealth have 403 rights?
They
do. The
do.
rule of evidence applies to everybody, right?
They have those rights, but I think when it is against the defendant or a party in a civil case, I think the court has to be a little bit more concerned than an institutional party.
Is that in 403?
It's not in 403, that's to be sure, but I think that plays out in this is a general theme in the case law. I can't cite a specific case that says that exact statement, but I think that's why there's a different test for under Creighton for defendants, prior bad acts versus victims, for example, which is traditional 403. So yes, the court would have to do the 403 analysis, and that wasn't done because it wasn't brought up at the trial level. And then the motion judge essentially said, citing adjutant basically as the rationale, that implicitly the motion judge thought that the jury might think the victim deserved to die. And I think that is really not putting a lot of faith in juries, that they would hear about the victim having committed this crime, to be sure, distasteful crime, and therefore disregard all the Commonwealth's evidence as to what the defendant had done and simply say, well, whatever happened, he deserved it. I think that does not put enough.
Where was the sudden combat?
Well, the evidence was that they essentially were having some sort of a verbal dispute inside.
And they walk out together.
They walked out, so having, presumably, you could infer, continuing to have some sort of verbal dispute. And then the victim walks ahead, and the defendant pursues, and then they engage what appears to be mostly off screen for about 15 to 20 seconds in some sort of fight. Now, the Commonwealth's theory was that at that point, the victim had already been stabbed in the back, but I don't think that that is something that is undisputed. In other words, the judge, by instructing on self-defense and manslaughter,
Sudden combat's a subset of reasonable provocation.
it's related. It's definitely,
It's a subset.
well, I mean, I know cases have said that, but it does, but I,
If Howard says that,
Yes.
you disagree with that.
no, I'm not saying that. What I'm saying is that nevertheless, I don't think the court is going to rule here that as long as you give reasonable provocation, there can never be error if you refuse to.
That's not what I said. I asked you if it was a subset. You say it is.
You have said that it is.
Okay, it's a subset. You need sudden combat. So what you're saying to me is that this was mutual sudden combat.
I'm saying that the evidence fairly raised that inference, yes.
Well, how do you square that with the surveillance video?
So I can't square it with the surveillance video. I'm relying on both the testimony of Mr. Perkins and then some of the forensic evidence. So Mr. Perkins described a push, and he described the victim retrieving a screwdriver from his waist, jabbing at Mr. Ramos, the defendant, and then Mr. Ramos pulling out a knife and stabbing him. There was also evidence of blood on the screwdriver, and there were two holes in Mr. Ramos's jacket. And so based on all of that, the judge gave the self-defense instruction and 2 of the 3 manslaughter instructions. And so the trial judge thought that even though the surveillance video showed what it showed, that there was enough evidence at least to raise a reasonable doubt as to whether Mr. Ramos was in fear of his life.
So is your contention that the judge committed an error of law in not sua sponte instructing on sudden combat because counsel withdrew it, or is your claim? I thought your claim was that it was ineffective assistance of counsel to withdraw the request for.
I believe we framed it as it was an error for the judge to go along, to acquiesce to the withdrawal. It's an unpreserved error, essentially. I believe that's how we framed it. I don't know that.
It's an invited error. It's not unpreserved error. It's something the judge did what counsel asked.
That's correct. Trial counsel did ask for it to be withdrawn based on a case, I think probably was the Howard case, although we don't know for sure, which didn't really give any reason to do that because there was evidence here of physical contact between the two. And Howard says you have to have physical contact, and here there was. So I'm not really sure why trial counsel and the trial judge relied on a case that they didn't put on the record what the name of it was to not instruct on that theory. But we framed that as an unpreserved error, invited error, you could call it. The Commonwealth did not make any argument here that would change the standard from substantial likelihood of a miscarriage of justice, and so that's how we framed it. So if there are no other questions, I'm happy to rest on my brief.
Okay, thank you. Attorney Lynch.
Good morning. May it please the court. Travis Lynch for the Commonwealth. With respect to the ineffective assistance of counsel claim, Mr. Brown gave a clear explanation for why he chose not to seek to present the adjutant evidence. It was credited by Judge Callan.
Why not take a shot and see what Judge Sweeney would say?
Well, just because you could do that doesn't mean that you've fallen below the manifestly unreasonable standard. I mean, certainly you could have tried to do that, but that doesn't mean that he was constitutionally required to do so, because he didn't want to create the opening. And again, if he had offered,
If he moves for the adjacent evidence, and she does the 403 analysis and says, sure, I'm gonna allow in the rapes and the indecent A and Bs, then you move to whether or not adjacent evidence comes in, and at that point he can withdraw, right?
right, I mean, he could have done that, sure. But we're talking about whether he was required to do that. And again, we would just say he's not required to do that under the circumstances. I think he is legitimately concerned about the possibility of the counter-adjutant evidence coming in. I mean, if he had offered the evidence, the judge hypothetically let it in, and then the Commonwealth said, well, we're gonna put in your stuff now, we would be in exactly the same position as we are now. So I don't think he's required to go through those steps in order to be said to not be ineffective or not to have made a manifestly unreasonable decision.
But he also would require the Commonwealth to find its witnesses to prove the counter evidence, right?
Right. I mean, but we don't know that in this posture because we're here on an ineffective assistance of counsel claim. But I don't think that the Commonwealth in this posture, I mean, we don't have a burden of proof, obviously. I don't think that we were required to somehow show that back then we would have been able to marshal that evidence in order for us to say now that Mr. Brown's decision was not manifestly unreasonable. I mean, part of the problem here is that we don't, there's speculation upon speculation, but that's how a lot of these ineffective assistance of counsel claims work out. In any event, the evidence probably wouldn't have come in anyway. The sexual assault evidence is so plainly gross, unfairly prejudicial to the Commonwealth. The Commonwealth, as you said, has 403 rights too, because we're a litigant just like the defendant. And the victim didn't use deadly force in those. I mean, I'm not using an elements-based test. I'm just saying he didn't use a weapon. There's nothing like that in the sexual assaults. I think the abhorrent nature of that conduct speaks for itself. I don't think Judge Sweeney would have ever let that evidence in. I don't know any trial judge that would ever let in sexual assault evidence. The resisting arrest charge, Sanchez was in an apartment that it looks like he was some sort of squatter in an apartment. And then when the police show up, he resists their arrest. That is not terribly probative of whether on this occasion he would have pulled out a screwdriver and attacked the defendant with it. I'd also note that those incidents took place years before, I believe somewhere between 7 and 8 years prior to this conduct, which happened in March of 2015. There's also, we actually don't even have the facts as to the other case that the defendant refers to, the assault and battery charge that Mr. Sanchez pled guilty to in an unrelated complaint.
In a close case like this, though, so even if those things were minimally probative, and I don't disagree with you on that, wouldn't they still have some relevance to some kind of coercive aggression? Would they still have? I mean,
well, I think that we're talking about substantial likelihood. If it's improbable that a judge would have let it in anyway, then there can't be a substantial likelihood. So I think there's a pretty powerful argument to say none of this gets let in by the trial judge if it had been offered in a timely fashion. And also, assuming that, I mean, the sexual assault evidence is right out. That's never coming in. But the resisting arrest charge, the A and B about which we know nothing, assuming that even came in at all, it doesn't look like this case at all. It doesn't really shed any light. So even if on whether Mr. Sanchez would have attacked the defendant with a screwdriver, so I think that even if it had been offered and it had been admitted somehow, I don't think the jury would have really made much of it. They rejected Perkins's testimony outright, clearly. I think the video is quite powerful evidence here. There's the forensic evidence with the stab wound to the back. I mean, the stab wounds were severe, and the evidence was also quite clear that Mr. Ramos was uninjured. There's other problems with Perkins's testimony. He denies that the green knife that the defendant dropped was the knife that was used in the stabbing. He said it was a sheetrock edger instead that he used. The screwdriver that the police found with I believe, a yellow and gray handle, not the screwdriver that Perkins claimed the defendant, Mr. Sanchez used. completely different screwdriver. So there's all sorts of, I mean, I just don't think that even if, say, the resisting arrest or the fact of the A and B conviction had come in, I don't think it would have made a difference here, given the strength of the Commonwealth's case. So there's no first prong of an ineffective assistance of counsel claim here, and there's no substantial likelihood. I don't think there was a suggestion in the brief that to send this back. I don't think there's any point in doing that here. With respect to the instructional claim, if I may move on to that, the defendant received the reasonable provocation instruction, which, as you say, it's more like sudden combat is a subset of reasonable provocation. The reasonable provocation instruction here actually tells the jury to consider whether there was a physical blow, and which is much the same as the sudden combat instruction. So at least on these facts, I think that the reasonable provocation instruction covers almost all the same ground that the sudden combat instruction would have covered. They were still directed to consider the victim's conduct in determining whether the defendant acted under the heat of passion without malice. I mean, I don't think they used the word malice, but so, and they necessarily rejected that there was mitigation here. They were directed to determine whether there was mitigation. They found there was none. I think there was a question about, does it matter how it's framed? Is it a judge error? Is it a attorney error? I think that the answer to that is, it doesn't really matter because it's all under substantial likelihood under 33E. There's some force to the idea that, I mean, it would have been nice if, for present appellate purposes, this instruction had just been given, because we can say with quite a lot of certainty that it wouldn't have made a difference anyway. I will say, I've had the unfortunate experience in charge conferences of defendants objecting to manslaughter instructions where the Commonwealth says, just give the manslaughter instruction. I don't think that the prosecutor could have prevented this claimed error from happening. But I just find it interesting that the defendant is allowed to withdraw his request and then claim on appeal that there's a substantial likelihood. But in any event, there is none. There's a 33E argument, but he's essentially asking you to credit Mr. Perkins' testimony over that of all the other witnesses. If you credit, or if you discredit Perkins, this is just murder. That's plainly what happened here. The jury clearly discredited Perkins. There's every reason to do so. And the video is quite powerful evidence. Unless there's any additional questions, I'd ask that you affirm.
Okay.
Thank you.